Good evening, everyone. Let's wait for half a minute for all the participants to join. Good evening. On behalf of Taxsutra, I extend a warm welcome to all our participants for today's webinar hosted in collaboration with AKM Global on a topic that continues to gain relevance and complexity in the evolving enforcement ecosystem. Intricacies of attachment under PMLA, recent trends from attachment to restitution. PMLA has emerged as one of the most potent legal tools in India's fight against financial crime. At the heart of this enforcement framework lies the process of attachment of property. Today's session aims to unpack the complexities from the intent and scope of attachment proceedings to the questions of what constitutes property, how substitution is handled, and the legal pathways to restitution. To take us through these dimensions, we have with us Mr. Anirudh Sood, who leads the white-collar crime defense practice at AKM Global. Mr. Sood is a gold medalist in law from Himachal Pradesh University and a recipient of multiple academic honors, including a junior research fellowship and 3 gold medals in his master's in criminal law. His professional journey is equally distinguished. He has worked as a legal researcher to Honorable Justice Surya Kant and Justice Sanjay Karol of the Supreme Court of India. Anirudh brings with him over 8 years of rich litigation experience and has also served as a legal consultant and counsel for the Enforcement Directorate. He has also represented ED in over 150 high-stakes matters under PMLA, FEMA, and Fugitive Economic Offenders Act, and has served as a special public prosecutor in sensitive, high-value cases involving bank frauds and illegal activities. His deep understanding of bail jurisprudence, prosecution strategy, and cross-agency enforcement makes him uniquely positioned to guide us through today's discussion. We welcome you, Mr. Sood. And before I hand it over to our speaker, a hygiene announcement for all our participants. Participants, in case you wish to ask any questions, please do post them in the Zoom Q&A box. We will be having a dedicated Q&A session at the end of the webinar. And with this, over to you, sir.
Right. Thank you so much for this overwhelming introduction. Good evening, ladies and gentlemen. I am Anirudh Sood, working as lead white-collar crime defense practice at AKM Global, a firm that has pan-India presence along with overseas presence. The vertical is being headed by Mr. Amit Maheshwari, the tax partner AKM Global, a thought leader and who appears constantly in the domestic as well as in the international media. Now, to set up the agenda of this webinar in collaboration with Taxsutra, we'll be dealing with 3 aspects to understand what is the nature and also the intent behind the attachment proceedings executed by the Enforcement Directorate under PMLA, also to gauge an overview to have an understanding as to what kind of properties are amenable for attachment under Section 5 of the PMLA, and then what is the recourse available. Can it be substituted? In what cases? Can it be restored back? In what cases? Section 5 of the Prevention of the Money Laundering Act 2002 that provides and that confers with the powers of attachment of property which is involved in the offense of money laundering with the Enforcement Directorate, the agency that enforces the Prevention of Money Laundering Act in India. Now, the authorities that are empowered are the director of the Directorate of Enforcement Directorate or any other officer, but the officer should not be below the rank of the deputy director. Now, what is the basis for the attachment of the property? The Section 5, subsection 1 would say that any person who is in possession of proceeds of crime, such proceeds, and there is a reasonable apprehension with the concerned authority, with the concerned officer, that the proceeds of crime are likely to be dissipated, they are likely to be disposed of, in case the property, the concerned proceeds of crime are not attached under Section 5. And the alienation of the property in the absence of the attachment proceedings is likely to frustrate the proceedings related to confiscation of the proceeds of crime. Confiscation of the proceeds of crime happens pursuant to a trial when the trial would lead to conviction. There is also a non-conviction based confiscation that I will be taking up in the later part of the discussion. Now, as it says that from whom the property can be attached. So it can be any person, but the person has to have that possession of the proceeds of crime. Now, interestingly, this section does not have the element of mens rea, that is the mental element. So, possession without knowledge or possession with knowledge, the knowledge in respect of the nature of the property that you are holding, whether it is proceeds of crime or not, it would be irrelevant for a proceeding under Section 5 of the PMLA. So, if you are in possession of proceeds of crime, whether or not the fact that the proceeds of crime or the property is the proceeds of crime or the property is having tainted source is insufficient, is immaterial, and an action under Section 5 would be maintainable. Then what are the conditions precedent for the attachment of the property under Section 5? The proviso to subsection 1 of Section 5 would say that there should be a charge sheet filed by the concerned law enforcement agency or a complaint by the officer who's authorized to file a complaint under the Act. Likewise, it happens in the Income Tax Act, or for that matter, under any other law where the law enforcement agency would not file a charge sheet but would go for a complaint, a prosecution complaint. Likewise, in the case of SFIO. Uh, However, the second proviso enables the enforcement directorate to bypass this condition. So if the enforcement directorate, that is the authorities, the deputy director or any senior officer above him, is of the opinion and has reasons to believe, based on the material that is in his possession, that if he does not proceeds to attach the property which is proceeds of crime, and there is no charge sheet filed in respect of the predicate offense or the scheduled offense, or a complaint by the authorized officer in any other law for the time being in force in respect of the scheduled offense, then he may bypass the first condition, that there should be a charge sheet or a complaint that should be already filed in respect of the scheduled offense. So filing of charge sheet or a complaint in the scheduled offense can be bypassed, and the power has been conferred in the second proviso of Section 5, whereby the officer authorized under the Act, that is the deputy director or any senior officer above that rank, can proceed to attach the property bereft of a charge sheet or a complaint filed in that case, in the scheduled offense. But what is to be recorded in the reasons, that in case the property is not attached and they keep on waiting for the charge sheet or the complaint to be filed by the concerned law enforcement agency, or for the investigation in the scheduled offense to be concluded, if they wait for the conclusion of the investigation, the proceeds of crime are likely to be disposed of or alienated, and as such the disposition or the alienation of the proceeds of crime would frustrate the proceedings of confiscation under the Act if the property is not attached. Now, interestingly, Vijay Badal Lal Chaudhary and others versus Union of India and others, which came in the year 2020-22, Honorable Apex Court has given a wide power. It says that even a pre-registered scheduled offense is not required. What can be done if the ED apprehends in its inquiry that is being conducted that there is a scheduled offense that has been committed, which is an offense as per the schedule appended to the PMLA, that is, it is a scheduled offense, but it has not been reported, it has not been registered. In that very case, the enforcement directorate can directly proceed to attach the property, but what is required is a contemporaneous communication with the concerned law enforcement agency under Section 66 subsection 2 to get the FIR or a complaint for that matter registered. So this is the you can say the broadening of the power, or the one aspect or the dimension that has been brought by the Apex Court by virtue of the pronouncement in the Vijay Madan Lal Chaudhary and others. Insofar as the validity or the tenure or the period of the provisional attachment order is concerned, it should be valid for a period of 180 days from the date of its issuance. And it will exclude the period of stay that has been granted by a high court in respect of the provisional attachment order. And further, a period of 30 days is to be counted for the purpose of exclusion after the vacation of the stay order. Now, insofar as what is the process, what is to be done within those 180 days by the enforcement directorate, within the first 30 days, an original complaint has to be filed before the adjudicating authority, that is the first statutory forum, before where the adjudicating authority will seek the confirmation of the property which has been attached by it under Section 5. So that is to be done, that complaint filing has to be done within a period of 30 days. And the remaining period, say the remaining bracket, that is of 150 days, that is for the adjudicating authority to hear you, to issue you an show cause notice, and to take your submissions on record, to take the rival submissions of the enforcement directorate on record, and to give you an opportunity of being heard, and then to come to a conclusion whether the property is proceeds of crime and is liable to be attached or not. Then, insofar as the attachment is concerned, one thing that people really fear of is that what happens if the property is attached, is the possession to be given up immediately as soon as you receive a provisional attachment order. That is not the case. The department will not hinder or interfere with your possession, with your enjoyment, with the right of the enjoyment of the possession till the property is confirmed by the adjudicating authority. And pursuant to that, in terms of section 8(4), the possession can be taken. Interestingly, Honorable Apex Court in Vijay Madan Lal said that not in every case you have to take the possession once the attachment has been confirmed. It has to be done in exceptional circumstances. Now, to dwell on that, what are the exceptional circumstances that Supreme Court has not called out? It now becomes a matter of policy for the department to formulate and to call down what circumstances could be said as exceptional circumstances for the purpose of taking possession of the property pursuant to attachment and its confirmation. Okay, coming to the next aspect, that is the nature and the intent of the attachment proceedings. So under the PMLA, we have two set of proceedings. One is a civil proceeding, one is a criminal proceedings. So insofar as the attachment is concerned, attachment, the adjudication by the adjudicating authority of that particular attachment and subsequent confiscation by the special court. This is civil action. Search and seizure also, and also survey under section 16 would also classify as a civil action. Insofar as the criminal actions are concerned, the arrest and consequential criminal prosecution would qualify as the criminal action. We have some judicial pronouncement to that effect, which says that the adjudication, the attachment proceedings are civil in nature, starting from Vijay Madan Lal. Then we have Gujarat High Court's Fozia Samir Godel versus Union of India. Then we have Seema Garg versus Deputy Director, a pronouncement by Honorable Punjab and Haryana High Court to that effect. Now, coming to the intent of the attachment proceedings. See, intent of the attachment proceedings is to secure the proceeds of crime for the purpose of confiscation. Now, the confiscation, the stage of confiscation is post the conclusion of trial in terms of section 8(5). 8(5) says, when the trial court, when the special court trying the offense of money laundering has come to a conclusion that the offense of money laundering has been committed and it proceeds to convict the accused for the offense of money laundering, then the confiscation of the property which has been attached by the enforcement directorate, which is subsequently confirmed by the adjudicating authority, that property shall stand confiscated to the central government. In terms of section 9, which says that the confiscated property will vest in the central government free from encumbrance. Now, the expression free from encumbrance would also qualify that the intent is that the enforcement directorate, by passing of a provisional attachment order, by attaching the property, also restricts and abstains the owner of the property to create a third party right in the said property. Now, creation of third party right, when viewed from the department's perspective, could also land someone in trouble. So, for example, during the the period during which the property is attached, in case there is a third party right that has been created by the person from whom the property has been attached, that is the owner of the property, in that very case, this third party, whether it is a bona fide purchaser or not, that will be investigated by the department. The department would also go on to investigate the sources of the funds of the third party purchaser, because the department will try to investigate whether or not the third party purchaser is a benamidar, in the sense that if the source of fund is backed by the accused of the offense of money laundering and the trail behind the consideration which has been paid by the third party purchaser is tainted, in that very case, even the third party purchaser could be prosecuted for the offense of money laundering. So that is the intent behind the attachment proceedings, that it is ultimately the intent is to secure the property for the purpose of its confiscation, that is to be executed by the special court post the conclusion of the trial, where the trial would lead to conviction. Now, coming to the next aspect of this webinar is what kind of properties are amenable to attachment under Section 5. Now, when we say that proceeds of crime are to be attached, let me just take you just quickly recollect what exactly proceed of crime would mean. So proceed of crime, when defined in the Act, it says under 21U that it is property derived or obtained directly or indirectly as a result of criminal activity relating to scheduled offense. Why this has been highlighted and underlined is because this expression is wider in nature as compared to an expression when I say that the property is derived or obtained as a result of a scheduled offense. So these are two expressions. For the purpose of understanding, please try to understand that the expression used in the Act under 21U, that the property derived or obtained directly or indirectly as a result of criminal activity relating to the scheduled offense. It does not say that it is directly or indirectly derived or obtained as a result of scheduled offense. It includes another expression, that is criminal activity relating to scheduled offense. I'll give you an example. In the Gurgaon, in the very famous Gurgaon land scam case, if somebody remembers this Supreme Court judgment, Rameshwar and others versus State of Haryana and others, which came in the year 2018, pursuant to which the entire land acquisition that was conducted by the government of Haryana, and the acquisition proceedings were dropped, the apex court held that this entire exercise was to defraud the farmers, the landowners, and the intent was land grabbing and further selling the land to such landowning companies and to the private builders and promoters. So the entire, you say, the acquisition proceedings and subsequently the notification of withdrawal of the acquisition proceedings by the government of Haryana was viewed strictly by the apex court, and it was held that the entire acquisition and the subsequent withdrawal was nothing but an exercise to defraud the landowners, and it was a land grabbing exercise. So insofar as this case is concerned, there were certain landowning companies which has procured a license from the Directorate of Town and Country Planning for the purpose of development of a residential colony therein. Now, what the landowning companies, the accused in the Gurgaon land scam case, in the PMLA ED case, they have sold the license along with the land. I mean, the entire landowning company has been sold to the main accused, who was ABWIL Group, which the ultimate beneficial owner was Atul Bansal. So the department has gone to the extent of taking note of the profit that was made by such landowning companies when they have sold off the land along with the license that they have obtained from DTCP. That the profit that they could earn, these landowning companies, this is nothing but this is a property which they have derived out of a criminal activity which is relatable to the scheduled offense. Now, what was the scheduled offense? Scheduled offense was your 120B, that is criminal conspiracy of the erstwhile IPC, 420, that is cheating the landowners, forgery for that matter, 465, 467, 471. But the amount that they have gained by way of selling of the licenses that they could procure. Now, interestingly, just to make it more simple and lucid for your understanding, see, obtaining license upon a property is per se not illegal. But when viewed in the context of the relation that it has with the scheduled offense that stands committed prior to it, then the gains that have been made by a person by selling that license along with the land upon which the license has been issued would be viewed as a proceed of crime, because it is derived as a result of criminal activity relatable to the scheduled offense and not directly from the scheduled offense. So the expression result as a result of a criminal activity relatable or relating to a scheduled offense is wider enough, and it encompasses a lot of things. So this is first, this is the proceeds of crime. Secondly, if the proceeds of crime cannot be found, then it is the value of such property. And thirdly, in case the property that the proceeds of crime have been transferred outside India, it has been sent to some foreign jurisdiction, then the property, equivalent property that is situated in India, that would qualify to be proceeds of crime, and that proceed of crime can be attached by the Enforcement Directorate by, under Section 5. Coming to the definition of now property, that is 21V. Why actually, I mean, it is very simple to understand. The intent of explaining 21V, the explanation that we have appended to section 21V, it says property includes property of any kind used in the commission of a scheduled offense under this act or any of the scheduled offenses. Now, the last expression that you see appearing in the last line of the explanation, that it says or any of the scheduled offenses. So property which is used in the commission of a scheduled offense whether that would qualify as a proceed of crime or not, that is interesting, and that is what is to be deliberated upon. Insofar as this last expression, which I'll take you again to, any of the scheduled offenses, that means property that is used in the commission of the scheduled offense, whether that can be attached under section 5 or not. Because if you see the conjoint reading of 21V and 21U, 21U uses the expression property, right? Just 1 second. Property, proceeds of crime is a property derived out of the scheduled offense, right? Now coming to 21V, property is defined as the property which will include corporeal, incorporeal, movable, immovable, tangible, intangible, etc. But when you read the explanation goes on to include a property which is not only used in the commission of an offense under the act, that means an offense of money laundering, but the property expression appearing in 21V would also include a property that has been used in the commission of the scheduled offense. So this is something that has to be understood. In respect of this, there's a clarification that has been given by Vijay Madan Lal. And I think that's a very apt clarification, because if we read the two provisions, 21U and 21V conjointly, the result would be a little absurd. Now, why? And I'll explain you with the help of the examples that were quoted by Honorable the Supreme Court in Vijay Madan Lal Chaudhary. See, it says the first example is that vehicle which is used in the commission of the scheduled offense may be attached as a property in the concerned case, that is, in the scheduled offense. It may still not qualify to be proceeds of crime within the meaning of 21U. That means if a person, say a group of 4 people, they proceed to commit an offense of robbery, and for the purpose of committing robbery, they're using a vehicle. So the proceeds of crime that would be generated out of the offense of robbery would be the amount that they have been able to rob from the bank. That is proceeds of crime. But whether the vehicle that was used for the purpose of commission of the robbery, whether that is proceed of crime or not, if you read the explanation that is appended to section 21V, it would say, and it would mean that property would include any of the property that is used in the commission of scheduled offense as well. But then when you read it with 21U, you would come to the conclusion that because property here, which is appearing in 21U, would include a property which is used in the commission of scheduled offense, then in such case, the vehicle is also liable to be attached as a proceed of crime. But this was clarified by the Supreme Court. It said that this kind of interpretation cannot be governed. This is a very absurd interpretation, because what property would qualify as a proceed of crime is that there is a commission of a scheduled offense, and subsequent to the commission of the scheduled offense, or as a result of the commission of the scheduled offense, some property has been derived. The vehicle which I've used in my example, the vehicle which was used by the robbers to rob the bank and to collect the money and to transport of the as a conveyance, right? In that example, the vehicle is already there. That property is already there prior to the commission of the scheduled offense. So by no stretch of imagination can that be construed or qualify the conjoint interpretation of 21V and 21U to be classified as a proceed of crime. Secondly, Vijay Madan Lal also explained that if the department comes to the fact that there is some unaccounted cash lying at someone's premises, that unaccounted cash may be through some legal sources, until and unless it is proved that the unaccounted cash has emanated from an offense, from a crime which is a scheduled offense under PMLA. Only in such situation that unaccounted cash and unaccounted property would qualify to be proceed of crime, otherwise not. Then there is an explanation that was given, or I can say the categorically explanation or a clarification by the Delhi High Court in the Deputy Director versus Axis Bank case, which goes on to explain the concept of alternative attachable property, which says that when you are not able to trace, or when you are not able to figure out or identify the actual proceeds of crime, in case the actual proceeds of crime have been disposed of, in that very case, the alternative value or the alternative property of the equivalent value can still be attached. And the view also stand reaffirmed in the Prakash Industries case. Now, because we are dealing with the kind of properties that are amenable to attachment, I have taken two very, these are the litigative issues that are popping up these days. a property that has been acquired prior to the commission of the scheduled offense, whether that can be acquired or not, that is something that has not been settled as of yet. There is a Supreme Court judgment in the year 2023, Pavana Debur versus Directorate of Enforcement, which categorically said that property acquired prior to the commission of scheduled offense is not proceeds of crime. But that judgment did not deliberate on the issue whether that property can still be made available for attachment or amenable to attachment under the concept of equivalent value. On that aspect, the judgment is silent. This aspect, when it was argued before the Kerala High Court in one of the cases, Satish Motilal Bidri versus Union of India, which follows the ratio of Pavana Debur versus Directorate of Enforcement and places reliance upon this apex court judgment, it has given a categorical observation that because Supreme Court is not of the view that property prior to the commission of the scheduled offense, which has been acquired prior to the commission of the scheduled offense, is a proceed of crime, then by no stretch of imagination, the department can go on to attach that property under the concept of value thereof, the equivalent value, or as an alternative attachable property. The concepts which were explained by the Delhi High Court in the Deputy Director versus Axis Bank case and Prakash Industries versus Enforcement Directorate case. Now, this judgment passed by the Kerala High Court, Satish Motilal Bidri, it has been challenged by the Enforcement Directorate in SLP before the Supreme Court, and the judgment, the operation thereof has been stayed. So there is, this question has still not been settled, because what is being argued by the department in such like cases where they proceed to attach a property under the concept of equivalent value, which property has been acquired prior to the commission of scheduled offense. Say, for example, the scheduled offense stands committed somewhere in the year 2020. The property has been acquired somewhere in the 90s, in the late 90s or the early 90s, way before the registration of the commission of the scheduled offense. So the departmental approach or the departmental argument in such like cases is that when you read 21U, I'll take you to 21U again. They say that the property can still be attached as a value of such property when when the department is not able to find the exact proceeds of crime, but has quantified and has come to certain figure that this much is the proceeds of crime. So they can attach a property which is not a tainted property. They can proceed to attach an untainted property also under the concept of equivalent value. Now, another aspect that arises with respect to the same issue when we speak of the topic, whether a property that has been acquired prior to the commission of scheduled offense, whether that can be attached or not by the Enforcement Directorate under Section 5. Now, the issue with respect to ancestral property, that has also been a subject matter of litigation in plenty of cases. Some of them I have highlighted. This one such case, that is by the Karnataka High Court, H.M. Malthesh and others versus Union of India. Now, there is a provisional attachment order attaching the ancestral property of the petitioner in this case. Karnataka High Court sets aside the provisional attachment order while it order dated 18th of December 2020. The department files an SLP. The matter gets remanded back to the Karnataka High Court. The Karnataka High Court, again by its order dated 10th of April 2023, sets aside the provisional attachment order, maintaining its earlier view. Now, department again files an SLP. That SLP got dismissed, not on merits, but in limine. And the question whether the ancestral property is amenable to attachment or not has still been kept open. That has been categorically recorded in the order itself. Though the order says that we are not inclined to interfere with the order dated 10th of April 23 passed by the Karnataka High Court after it has reconsidered the matter when the matter was remanded back to it. But the question of law as to whether the ancestral property is amenable to attachment or not under PMLA has still been kept open. So this is one such gray area that I felt like discussing. Now, coming to the substitution. Now, what is the remedy, or you can say, because I'll have to take you again to when I was talking about the third party, the rights, the third party right creation, wherein I say that the intent is not to create a third party right. I explained you one aspect that the department will interrogate and will investigate the third party purchaser also, whether he is a bona fide purchaser or not. what is the source of the consideration that he has paid in respect of the property that was already under attachment. And practically, it is very difficult to get the property alienated to a third person, because the moment the department issues a provisional attachment order, a contemporaneous communication is sent to all the registrars and sub-registrars of the concerned tehsil in which the property is situated, that no alienation can be done in respect of this property because the property has been attached by the enforcement directorate. Because we are dealing with certain cases where the third party purchasers have been duped and they were not informed by the by the concerned person whose property was attached. He has paid a considerable amount of money pursuant to an agreement to sell that was executed between the person whose property has been attached and the third party purchaser. Now the third party purchaser claims that I have been duped, my source of consideration is clean, it is untainted. Now what is the remedy available with me? His remedy is restitution, right? That will be taking up in the subsequent part. But whether a property which is attached under section 5, can the property be substituted by offering some alternative property or some alternative arrangement in terms of a bank guarantee or by way of furnishing any fixed deposit for that matter? That is another question. So there are certain judicial pronouncements that I'll be taking you to. But prior to that, let me categorically clarify this, that there is no specific provision for the substitution of a property which has not been confirmed by the adjudicating authority, in respect of which only a provisional attachment order has been passed and the confirmation by the adjudicating authority is pending. So there's no specific provision, rather it is a relief which is more in the nature of an equitable relief and cannot be claimed as a matter of right. When you come to the PMLA taking possession of attached or frozen properties confirmed by the adjudicating authority rules 2013, these rules would apply to properties which have been attached or which were frozen under section 17 and which properties have been confirmed by the adjudicating authority. That's why at the outset I clarified that in respect of the property which is attached and the confirmation proceedings are still pending, nobody can claim a matter, or nobody can claim a substitution of that attached property as a matter of right, because there's no enabling provision to that effect. If I take you to Rule 4 Sub Rule 2, it says that where the property has been attached and has been confirmed by the adjudicating authority and the nature of the property is such that it is liable to speedy or natural decay, or the expense is likely to exceed its value, in that case the authorized officer is empowered to sell the property and to have the proceeds deposited in the government treasury or in the branch of the State Bank of India or any subsidiary or the nationalized bank. So this is something that empowers the authorized officer, not the person whose property has been attached and subsequently confirmed. The proviso to this rule, sub rule 2 of rule 4, say that when the person himself offers, that now it talks about the owner of the property, when the owner of such property, right, which is liable to speedy or natural decay, when he himself furnishes, say a fixed deposit of a nationalized bank of the same value of the property, then in that case also it is the discretion of the authorized officer whether to accept that or not, or whether to proceed in terms of rule 4 sub rule 2. So this proviso gives the owner of the property a mere right, not a right, but you can see it enables him to furnish a bank deposit, a fixed deposit of any nationalized bank having the same value of the property that has been attached, but acceptance thereof is subject to the discretion of the authorized officer, and it cannot be claimed as a matter of right here also. Then coming to the second proviso of the rule 4 sub rule 2, it says where you have attached the conveyance, which is in the nature of a movable property, then in that case also the authorized officer, it is his discretion whether he wants to do so or not. He can obtain a valuation report from the motor licensing authority. In such cases, the last insured value of the vehicle that generally works. So as the case may be, he may accept and retain the fixed deposit receipt of the nationalized bank. So that is his discretion. The owner of the movable property which has been attached and confirmed by the adjudicating authority, he can offer a fixed deposit which is equivalent to the last insured value of the vehicle. Whether or not to accept it, that is purely the discretion of the your authorized officer. Now, coming to Rule 5, Sub-Rule 5, which is with respect to the immovable property. Rule 4 is only with respect to the movable property. Now, there is one enabling provision under Rule 5, Sub-Rule 5. It says where your immovable property, which is in the form of land, building, house, or flat, is under the joint ownership, then in that very case, the authorized officer may accept the equivalent value of the fixed deposit to the extent of the value of the share of the concerned person. So, for example, there are two brothers and they're having a joint, there's a joint property, they're co-sharers in the property. Now, the department has proceeded to attach the share of that person, say, of one of the brothers who is accused of the offense of money laundering, and half of the share of the joint land has been attached under the concept of equivalent value. Then in that very case, the person, this person whose share has been attached by the enforcement directorate, he can offer the equivalent, you can say the fixed deposit of the equivalent value of his share, and accordingly that is also subject to the discretion of the authorized officer. In case he accepts, then in that case the property can be substituted by way of the furnishing of the fixed deposit of that value. But that is purely in respect of those properties which are attached and subsequently confirmed, right? There is no such provision in respect of the property which is in respect of which the confirmation by the adjudicating authority is pending. These are certain very important case laws that we have extracted. Some of them pertains to the apex court. Now, insofar as the first one is concerned, Vidarbha GE versus State of Karnataka, in this the Supreme Court has allowed the land to be released upon acceptance of upon furnishing of a fixed deposit to the tune of 1 crore 72 lakhs. SK Properties is another case by the apex court only. In this also the property, the department was investigating and was trying to attach a proceed of crime to the extent of 3 crores. But the property that it went on to attach, the market value thereof it was nearly, I think, 70 or some 80 crores. So in that case, because of the discrepancy in the property, the value at which it has been attached, for which it has been attached in the market value that it could fetch, the apex court has allowed the substitution thereof with the fixed deposit. So is the case in the Vice Bharti Reddy versus Enforcement Directorate. This also, the bank guarantee equivalent to the tune of 192 crores has been allowed by the Supreme Court to release the land. So is the case in Santur Builders, that is a Delhi High Court judgment, Revati Cements and Jai Durga Industries and other. These are all Delhi High Court judgments. And this also, the Delhi High Court has allowed the release of land, that is the immovable property, which was attached by the Enforcement Directorate, and the land was directed to be substituted by way of an FDR, by way of a fixed deposit. The last three that you can see, that is Omar Ali Obaid Balsharaf versus Deputy Director, Mrs. Alpha Avenue Private Limited versus Deputy Director, and 63 Moons Technologies Limited versus Deputy Director. These are the three orders that has been passed by the Appellate Tribunal PMLA, wherein they have directed furnishing of the indemnity bonds with an undertaking that in case the special court, which is seized off with the PMLA trial, if it concludes the trial in conviction, then they will be liable to pay the amount specified in the indemnity bonds. So these are certain judicial pronouncements which gives a notion that substitution, though, cannot be claimed as a matter of right because there's no statutory provision in the act or in the enabling rules to that effect. But there are certain equitable judgments, or you can say judicial pronouncements based on the equitable principles wherein such relief has been allowed to the aggrieved person. Coming to the last and very important aspect of the attachment of property under Section 5 is the restitution, wherein I would also recollect now at the cost of repetition the example wherein I say that there is some third party purchaser of the attached property or who is having some kind of a vested interest in the property, a legitimate interest in the property, who has been duped by the owner, who was accused of the offense of money laundering, and the property has now been attached. Substantial amount of consideration has been paid by the third party purchaser, but the property is under attachment with the enforcement directorate. What are the remedy and what are the rights available to him? To understand this, we'll have to understand the mechanism and the scheme of the PMLA that gives us two kinds of confiscation orders. One is a non-conviction based confiscation. The second is the conviction based confiscation. Non-conviction based confiscation, I'll take up first. That is under Section 8(7). Now, 8.7 says that when the trial of PMLA cannot be conducted by reason of death of the accused, or the accused having been declared as a proclaimed offender, or for any other reason, that the trial cannot be conducted. Last one, having commenced but could not be concluded. That means the trial commenced, but the accused was either discharged or the proceedings stood quashed by the High Court in respect of the concerned accused. So, insofar as this is the criteria under which, these are the grounds based upon which, and these are the conditions in which the Enforcement Directorate can apply to the Special Court for the purpose of confiscation of the confirmed attached property without there being any conviction pronounced by the Special Court on record. Now, the power of now, insofar as this property, the confirmed attached property, which has been confiscated in terms of 8.7 in such situations where the accused is dead, or where he has been declared as a proclaimed offender, or where for any other reason the trial cannot be conducted, or the trial have commenced but could not be concluded. In the example that I've given you, where the person has been discharged, or the proceeding stands quashed against him by the High Court. In such cases, the property can be directly confiscated to the central government pursuant to exercise of power under section 8.7. Now, what is the remedy, you can say, which is available? So the remedy available to the person is that whosoever is entitled to that property, whosoever is claiming the possession of the property in respect of which an order under 8.7 for the confiscation has been passed, he can apply to that same special court which has confiscated the property under section 8.7 for the release thereof. And the court, because there's no specific provision, but the court would obviously incorporate and adopt the principles of natural justice, would call upon the Enforcement Directorate to reply to the application, and then would consider the merit of the case and the material before it, and whether the person is entitled to the property or not, that would be considered. And if he so, then the property would be restituted or restored back to such person. So the example that I gave you, where the person has been duped by the accused or by the offender of the offense of money laundering, whose property stands attached, and this attached property has been sold or has been purported to be sold upon an agreement to sell, and pursuant to agreement to sell, some consideration has flown from the third party purchaser. In that case, that third party purchaser would have a right if this property is confiscated in terms of 8.7. Now, coming to conviction based confiscation, that is in terms of section 8.5. I explained you 8.5 earlier also when I was explaining the intent behind the attachment proceedings, wherein I said that the intent is to secure the proceeds of crime for the purpose of confiscation under section 8.5. Now, 8.5, when the trial is concluded in the conviction, it results in the conviction, the special court would proceed to confiscate the property to the central government. Now, the question is, who can file an application for the restitution in such like cases? In the conviction based confiscation, the application for the restitution can be filed by a claimant with a legitimate interest who has to prove that he has suffered a quantifiable loss as a result of money laundering. Now comes the stage at which stage before the special court, when it is seized off with the matter, the application under section 8.8 would be maintainable. Now, there are two cases. First, when the trial has already concluded in conviction, then obviously post confiscation to the central government, post conviction, the application would be maintainable. In the other cases, now the other cases we say there is an enabling proviso, that is the second proviso of section 8.8, that says where during the course of the trial, the special court has been empowered to release the property. But when we read the expression that has been used in the special in the second proviso is that the special court during the course of the trial. Now, trial means trial would begin only pursuant to the framing of charge that has been clarified by the Honorable Apex Court in Catena of Judgments insofar as the criminal jurisprudence is concerned. The trial would only commence once the charge has been framed. So, filing of a prosecution complaint up till the stage of cognizance is a pre-cognizant stage. Post-cognizance and up till the framing of the charge is pre-trial stage. Once the charge has been framed, then you say that the trial has begun and the application under 8.8 would be maintainable. Now, what are the conditions that the applicant under 8.8 has to satisfy before the special court? That he has always acted in good faith. He suffered the loss despite having taken all reasonable precautions, and that he's not involved in the offense of money laundering. That means that an accused of an offense of money laundering cannot maintain an application under Section 88, right? Now, certain examples wherein the property has been restored back, these are certain orders that we could find out. There are certain more also that I would share for the information of the interested ones. First one is Rose Valley Assets Disposal Committee versus Rose Valley Real Estates Construction Limited. This is passed by the Honorable Special Court, the PMLA court, because generally CBI court is designated as a PMLA court under PMLA. So they use the expression CBI. So it's a special judge, CBI and PMLA Bhubaneswar, which has directed the enforcement directorate to release the movable properties to the persons having, to the applicant, along with the interest. Second is the Committee of Creditors versus Directorate of Enforcement. This is a Supreme Court judgment in relation to the Jindal Steel case, wherein the JSW has been was earlier when it was declared as a successful resolution applicant in the course of the CIRP, and it has taken over the assets of the Bhushan Power Limited. Now, in this case, interestingly, there's one aspect that when the committee of creditors, they went before the apex court under section 88, not under section 88, they pursuant to filing of a writ petition. Their claim was, and the motive of the petition was, that the question as to whether section 32A of the IBC would be applicable or not, that was to be adjudicated. But interestingly, the enforcement directorate said that we are not going into that question. We are treating their demand for the release of property as an application or as a right under section 88. And hence, we are not arguing on the point whether 32A would apply in this case or not, whether it is retroactive or not. So this is one such example that we could find out. The other one are the special court orders from Bombay. In the case of Deputy Director versus Kingfisher Airlines, this is Vijay Mallya's case. They have ordered the restoration of immovable property to the applicant banks, which are the victims in such bank fraud cases. And the last one appears to be from another CBI court, wherein it has ordered the mortgaged and the property to PNB, which is the the claimant in that case, through the liquidator that was appointed. So these are certain cases. Now, another example in such like cases wherein the restitution application would be maintainable and is being filed, and the kind of litigation trend that we are seeing is in the builder buyer dispute case. So generally what happens if the builder is accused of the offense of money laundering, the entire asset, the entire projects get attached by the enforcement directorate. The units which have been allotted to the home buyers, even those get attached, because the reasoning that the enforcement directorate gives is that the conveyance deed, the registered sale deed, has not been executed as of now, and the sale based upon the agreement to sale cannot be recognized as a due sale in the process of law. So the home buyers, the aggrieved home buyers who, according to the payment plan, have paid almost 90-95% of the sale consideration to the builder who's already accused of the offense of money laundering, and the project stands attached, they are being aggrieved by the attachment. They are running from pillar to post. At last, when the proceedings are, the prosecution complaint is filed before the special court, the appellate tribunal and various high courts are relegating them back to the remedy that is available under section 88. That is, they're supposed to file an application under 88 before the concerned special court, which is seized off with the PMLA trial. The application would be maintainable only when the charge in the PMLA case has been framed. Now we're going to take up the question and answers. I think we still have 10 more minutes. If anybody has any question, I would love to address that.
Sir, right now we don't see any questions in the Q&A box, but we can wait for a couple of minutes for the participants.
Sure. They can do some brainstorming, and if they want to come up with some question, we can do that.
Sir, is it fine if maybe participants could mail you the questions if they have any, maybe they need time to...
Perfect.
Yes.
They can mail their queries. I would love to answer that. I think if we don't have questions, then
We can wrap up, sir.
yeah, we can call it a day
Yes.
then. Right.
Yes. Thank you so much, sir, for this deeply insightful and comprehensive session. Your practical experience and analytical clarity on this topic has definitely helped us today. Thank you so much, and we look forward to hosting you again.
Right. Thank you so much. It was a wonderful collaboration with Taxsutra. And these are certain topics that are really close to my heart because the litigation that we are into, and given my past experience and my stint in the enforcement directorate, I would love to have the queries mailed to me, and at any time the participants herein they can approach me, and I think my email ID is very much there. I think it's there in the brochure itself. I think they can access it and they can take my email ID from there. And thank you, Tax Sutra, for this wonderful collaboration and for this wonderful session. Thank you so much.
Thank you, sir.
Right.
Thank you.
Thank you.